Mr. Devins has to make an informed decision about who he wants as lawyers. He's now been sitting in our jail for 2,159 days.
Look at his face. He's like, damn, 2,100 days. Holy shit.
Does this have to do with Mr. Devins?
It does, Your Honor.
Okay. So can you give them a copy of the search warrant?
No, because it's a pending investigation that's still ongoing.
The state's seeking the death penalty. So you need to turn over the affidavit.
Judge, they've had since December of 23. They didn't even have the courtesy to inform us of a pending investigation. We had to learn this from Apple.
The YNW Melly double murder trial was a dumpster fire. Melly appeared in court for the first time in months to go over motions. The state executed a search warrant on Raven Liberty, who was Melly's defense lawyer, over a year ago and never told the defense. And it's regarding his witness tampering case. They think she's involved somehow, and they're still refusing to give over anything to the defense. And the state basically says, no, it's an ongoing investigation, and the judge is fed up. Like, he gets annoyed, you can tell. It's a shit show. Hit subscribe, here we go. First look at Melly's lawyer, Stuart Aldestein. Here's a new judge, Martin S. Fiend. There's Melly's family, his brother, and his mom is who I recognize. I don't know what's taking so long for Melly to come in court, bro. The stream's been on for an hour. Oh, they were told to get back a row. All right, here comes Melly. Oh, he cut his hair. Oh, shit. He looks so different. Doesn't look like he's in a good mood. I don't think anyone would be. Been in jail waiting for trial for 2,000 days. This old fart on the left is another attorney. I forgot his name. He wasn't on the last trial, though. Always smiling, looking over his family every time.
In preparation for the 2 days of all pending motions, I was going to put on the record, I know that the defense wants me to take one of these out of order.
Forgot how terrible the audio is in this courtroom sometimes.
Everything that I've read in preparation for the all pending motions that I gave you all day today and all day tomorrow for.
He's just listing all the shit that he had to read to get up to speed on how to decide things.
That's everything that I looked at, as well as any authority cited therein, statutes, case law, or otherwise. You don't have to repeat yourselves. I have the balance of all day today. I take a lunch break between 12:30 and 1:45. I can likewise give you the entire day tomorrow. I won't limit either side to present whatever evidence, witnesses, or testimony they would like to present. Defense, I'm going to start with you, and I also did read Rutledge versus State regarding the defense motion for hearing to determine potential conflict. So
this is about the video I made a few days ago. Melly's female attorney, Raven Liberty, is under investigation. The state did a search warrant on her Apple account a year ago. The defense had no idea about any of this until 2 weeks ago.
The first thing we need to know whether Miss Liberty is still under investigation. We're told before the hearing by the state, and I have no reason to doubt their word, that she still is under investigation. So that raises for us a number of problems. It may look on the surface that the only thing is, does Miss Liberty need to get permission from Mr. Devins to stay on the case and for him to waive conflict, but it's much deeper than that. And the reason why it's much deeper than that is we don't know what the state has subpoenaed. We do not know what they have in their possession. We do not know, other than the Apple accounts, if they've subpoenaed other things. Therefore, we do not know whether communications that we have had with Miss Liberty have been intercepted, and therefore, we've been told that nobody else on the defense team is under investigation, but there are certainly confidential communications that we would have had with Miss Liberty. There are communications about trial strategy that we would have had with Miss Liberty that we do not know who is in possession of them, what is going on with them.
Kind of crazy, right? The state has possession of her Apple account, bro. They could be seeing trial strategy. Honestly, it sounds like she shouldn't be his lawyer anymore. I'm going to be honest. Melly needs to think about getting rid of this lady.
Now, the case law seems to be pretty clear that during this type of process with an attorney who's on a case, that the state is bound to return innocent or innocuous or confidential communications to Miss Liberty. But she has not received any. In fact, she didn't know there were any that were to be received until the date that's mentioned in the motion. As I said, we've been told that the defense team, other than Miss Liberty, is not under investigation. But we do know that there's an ongoing investigation. We have now been working for nearly a year or over a year with the state being in possession of documents dealing with Miss Liberty. If in fact Miss Liberty has to get off the case, because of the conflict that she would have. This is a year too late. We should have been informed of this a year ago. So the defense team and Miss Liberty, and therefore Mr. Demons, for a year are working on this case with the state knowing that there's the potential that Miss Liberty will be indicted or an information filed against her in the exact same case of tampering with evidence and with witnesses.
Oh, so it's over the witness tampering. I mean, it had to be witness tampering, kinda. Remember, Melly was hit with witness tampering charges, so.
And if that becomes the case, she obviously, whether there's a conflict or not, that has been waived up until that time. I think the case law is pretty clear. At that time, if she has charges against us, she has to bail out. Defense counsel would have been under investigation for crimes that threaten the integrity and fairness of the trial. Were the government to inform the court at the eve of trial or during the course of trial that the defense team was under investigation for witness tampering,
If you're new to the channel, please hit subscribe. I appreciate the support. Back to the video, boys.
the defense team would be forced to withdraw its representation that had been intimately familiar with his defense, causing him severe prejudice. And that's where we're traveling down right now. Even if we stay on the case right now, if charges are brought against Miss Liberty and they happen to fall before the end of Mr. Demon's trial, we may be forced to, under the law, to withdraw as an entire defense team. But a question still needs to be asked. Why did the state wait, not to tell us, because they never told us, we had to find it out through Apple, that there was an investigation? Because a year ago, we would have sat with Mr. Demons, and he may have said, you know what, I need a new defense team. And we would have been off the case. But for a year, basically, we've been on a case that maybe we should not have been.
Holy shit, what a disaster, dude. And if the state charges her at any point in time, they could delay this trial again. Think about that. Imagine this trial gets delayed again. It's almost not even funny at this point. These murders occurred in October of 2018. What the fuck are we doing?
There are things that we need to know. We need to know who reviewed the warrant, who signed the warrant for the state as far as authorizing. We need to know whether there was a tainting. If all this information was gathered and given to the state attorneys that are prosecuting this case right now, there are innocent, innocuous, and confidential communications that will be in the hands of the state that is improper. A tainting should have been set up that reviews the documents and makes sure only those that are specific to the search warrant are looked at by the trial team. If in fact Ms. Liberty is under investigation, then why were the subpoenas sent out and why did that investigation begin now? And what I mean by that is there's a statute of limitation. The state was under no obligation to begin that investigation until Mr. Demons' case is over. Therefore, there is no perceived conflict. There is no conflict because we don't know that they're thinking about investigating Miss Liberty. But instead, we were not put in that position to know that, and a year went by. If they had waited to the conclusion of Mr. Demons' case, as I said, then there is no conflict. So the only thing that I get from this is that there's the chance that within the next whatever year, or 10 months until the trial date, 9 months, whatever it is exactly, that Miss Liberty is in fact facing charges for them. And if that occurs, then A, she can't try the case. Not sure the rest of the defense team can try the case. And don't know, and a prejudice to Mr. Demons would be monumental that at this late stage you'd have to get a whole new defense team. So we need these questions answered. It's not just a simple, is there an ongoing investigation? We need to know the extent of it. We need to know the whys of when it was instituted and why wasn't it, why didn't the state, wait for this matter to be over? We need to know whether the state, if they're going to charge Miss Liberty with this crime of tampering, do they intend to try her at the same time as Mr. Demons?
Dude, I don't think they're going to go over any pending motions today. It's going to be tomorrow now.
Obviously, at the same time, it even raises more of a conflict. We have a question, and that scares us. Miss Liberty has not been allowed to see Mr. Demons in person for the last, or at least the last year and a half. When she goes to the jail, she must pick up the phone and use one of those phones to talk to Mr. Demmons on the other side of the glass partition by phone. We need to know what communications, what has gone on. So it's not just as simple as, is there an open investigation? Now, as far as going forward on these other motions that you said, we can't go forward as a defense team on any of these motions until we talk to Mr. Demmons, have him understand what's going on. And for him, first of all, to make the decision. Yes, I want to keep this defense team. Yes, I want to keep Ms. Liberty. Or no, I need a new defense team. We can't do anything until that's decided. I will say that after doing the research that I did over the weekend and came up with the case I cited to the court, I think all members of our defense team need to call up the Florida Bar and to see whether we're obligated, now that we know that she's under investigation, that we're obligated or not to withdraw from the case. So that's where we stand today. With all apologies to the court, though, I do not believe we can go forward with these motions. Mr. Demmons has a lot of thinking to do. Hopefully the court will give us a hearing if some of these questions are answered, and then he can make a logical and an informed decision. And by that time, we can find from the bar whether we have obligations.
Look at the judge's face like, what did I get myself into? What a fucking disaster, dude. If this is really how this case gets delayed, I don't even know what to say anymore. The first trial was almost, it's gonna be 2 years coming up here pretty soon.
I read what Rutledge says, that's what I'm doing right now. But you want to know about investigations, you want to know about a judge who reviewed a warrant. How would you suggest I do that? And more importantly, do you have any authority that supports any of those requests you just made?
Well, the authority that I have, Your Honor, is the Sixth Amendment to the United States Constitution.
Judge basically said, do you have any authority to even ask for it? He's like, well, it's the Sixth Amendment.
Requires and which allows my client to have competent counsel. And without being able to go into these things, and I also rely on the 14th Amendment due process, without being able to go into these things and have a hearing where all these things are ferreted out.
I don't want you to confuse some type of hearing defending this liberty. That's not really the issue. That's a yes or no question. Is she under investigation? And the answer is yes. So the only other question that Rutledge requires is that Mr. Demmons has to decide, does he want to go forward with her, or does he want conflict-free counsel, which I think he's certainly entitled to. And if he wants to apply that to all of his lawyers, he may do that. But that's a discussion between you and your client. I can't intervene in that.
Oh, okay. So apparently Rutledge just says it's up to Melly pretty much if he wants to get rid of her and all his other attorneys. Which honestly, fuck, dude. I would just get rid of her and keep the other ones. Just get rid of her. He might have to. I don't think he wants to delay this any longer, so he just has to keep his other attorneys and get rid of Raven Liberty.
You're asking me to do fact-finding on behalf of your client so your client can make an informed decision.
Well,
right?
then I will file another motion for prosecutorial misconduct and ask for a hearing on that. Subpoena witnesses in. The state will move to quash the witnesses that I will be calling in, and we'll have hearings going down that path.
He said they're going to file another motion for prosecutorial misconduct. Oh my god, man. This is never ending. It's a never ending shit show disaster.
But I do not know how this court says that's the only thing that matters to me. There's a whole laundry list that deal with not only conflict.
That's what I'm asking. Do you have any case law that tells me I have to do that? I'm happy to do that. You cited Rutledge, and I read Rutledge. Rutledge doesn't
I
say
have
any
no
of those
case law in
things.
front of me right now that says you have to do that. But I would think it would be the inherent authority of this court that you should do that. And there's certainly nothing that says you can't do that.
I'm happy to do whatever a statute, case law,
Well, let's-
criminal procedure tells me to do. I don't make up things on my own.
Then I ask the court, let's go one step at a time. Right now, Mr. Demmons now has been informed that Ms. Liberty is under investigation, and let us see what he decides. If he doesn't want us on the case anymore because of this, then all the things I've raised will be raised by another set of counsel. But if he does, we will be filing other motions in order so that we can get these questions answered, because Mr. Demmons needs to know these.
So your request is you want me to hear any of these today? And
I don't think we can.
when would you like me to reset them?
I do not know how long it will take. Miss Liberty is not in town yet right now. She's on a plane. She got snowed in Montana yesterday. Drove from Montana to Seattle. She was on an airplane ready to come here, and they canceled the flight while she was on the tarmac. She got another flight including Phoenix. She is now on a plane from Phoenix to here. Almost all these motions that you went through are Miss Liberty's motions. So A, for logistical purposes, we can't hear those motions this morning at least. We're hoping that she's back at 1:30. But I do think It takes some time for us to talk to Mr. Demmons. She certainly needs to talk to Mr. Demmons.
So yeah, no motions today. Fucking great. Raven Liberty was snowed in Montana, drove to Seattle, then took another plane to fucking Phoenix, Arizona. What a disaster, dude.
We need to file a motion requesting certain things about this investigation concerning the taint team, whether or not they relayed any of that information to the prosecutors or the investigators in this case. And I want the court to know, they didn't tell us. Apple informed Miss Liberty that a search warrant was issued on her Apple account back on December 13, 2023. As a result of that, I contacted the Broward Sheriff's Office and spoke to Christian, and I sent him a text message that said, I was just advised that Broward Sheriff's Office issued a search warrant on Miss Liberty's Apple account on December 13, 2023, over 1 year ago. I would like to discuss this with you. He responded by saying, hi Stu, I have zero knowledge of this search warrant or its application. Your email is the first I have heard of this. I would defer to whoever the affiant was. I don't have access to that information. I in turn contacted the state, and they said they would get back to me, which I spoke for the first time this morning to the state concerning this. I think we need to know the procedure of the so-called taint team so that any privileged communications were not relayed to the prosecution team and or its investigators. We also need to know why, since Miss Liberty represents numerous other clients, whether or not they have severed or separated those privileged communications that have nothing to do with their so-called investigation. To find this out.
Well, do you even know that the investigation has to do with this representation? That's exactly what I was just thinking, what you just said.
Has anything to do with his representation? They fucking did a search warrant on his lawyer's phone. What do you mean?
Assume it is, since it's issued from the Broward Sheriff's Office.
How do you know it isn't related to one of our other clients or one of our other cases?
Well,
Has
that's all I
anyone said
have.
anything that this has anything to do with Mr. Demmons?
I can't answer that without seeing the search warrant.
And we're not here to make work. Does this have to do with Mr. Demmons?
It does, Your Honor.
Okay.
So can you give them a copy of the search warrant?
No, because it's a pending investigation that's still ongoing.
She said it does, and they can't give him a copy of the search warrant because it's an ongoing investigation. This is a disaster. This trial's never going to happen. This is fucking crazy. The guy's been in jail for 2,000 days.
How does Mr. Demmons make a decision about whether he wants to waive any potential conflict or not without having that information?
The only thing I can say, Your Honor, is again, it's a pending investigation. Knowing that she's under investigation is what Rutledge talks about. We can't give anything over until it's officially completed.
With all due respect, Ms. Buckley, this is the high due process part when the state's seeking the death penalty. The state's seeking the death penalty. So you need to turn over the affidavit and the search warrant so the lawyers can make an informed decision. All right?
All right, he just said, since they're seeking the death penalty, they need to turn this shit over, which is right. I mean, that's only fair.
It has to do with a homicide case.
Well, in any case, he needs to know there is a potential conflict of interest. He's either going to make an informed, intelligent waiver of that, or she will no longer be his lawyer. And then he has to make the same decision for all of his other lawyers. And he is going to trial September the 10th, 2025. So we need to do this now. So how long will it take for you to get a copy of the affidavit and a copy of the search warrant?
I'll have to speak with my office, and you can have a week to figure this out.
A week? Why do you need a fucking week? Dude, this should take 48 hours at the most. A week? The paper's already in the system. Give it over.
Judge, they've had since December of 23. They didn't even have the courtesy to inform us of a pending investigation. We had to learn this from Apple.
But you're telling me it relates to this case?
To the tampering case.
The witness tampering, which they also want to get into the trial, the murder trial, by the way. They want to show the jury that it's consciousness of guilt for Melly of witness tampering.
Why would this be different than any other search warrant in any other criminal case. The defense counsel would be entitled to it.
Because she's not a subject that's been charged yet, potentially could be. It's pending investigation. All I can say is, again, pending investigation, there is a team in place, and it's still pending. So it's not like we have to hand over discovery to her. She's not a listed defendant yet.
No, but let me repeat myself. Mr. Devins has to make an informed decision about who he wants his lawyers to be. He's now been sitting in our jail for 2,159 days. So how long would you like to be able to make that decision?
I can't determine when the investigation will be over. That's up to the Broward Sheriff's Office.
Look at his face. He's like, damn, 2,100 days. Holy shit.
But I can, as I said, I'm just asking for a week to determine whether or not we need to file any sort of motion to prevent the search warrant.
It's not funny. It's not funny. Just that reaction was actually...
And then I'm asking for at least a day or two, at
You
minimum.
decide by tomorrow. I've also reserved all of tomorrow. I took over Division FT. Judge Murphy had 44 pending first-degree murder cases. I've set them all for trial. I'm booked to trial through July of 2026. So if you all think I have 2 entire days at some point in the next 18 months to do these again, I do not.
This judge is booked through trial through July 2026. Bro's gonna be busy for the next year and a half. This shit can't get delayed because then it's gonna have to wait until after July of 2026. Oh, fucking please don't delay this.
I'm not sure what it is you want me to do. You don't want me to do anything else today.
We can't. Under the Florida rules.
So do you want me to leave them on for tomorrow? You will have the balance of today to discuss all these issues with Mr. Devins. And state you will have the balance of today to discuss some reason why you can't just turn over this affidavit and search warrant.
Look at the way Stort's looking at her.
I mean, it may be something innocuous. By the way, for the record, I don't know anything about this. 5 other lawyers to do this who are going to be ready to try a capital case in 9 months. So how about tomorrow at 9:30?
We'll be here.
State tomorrow at 9:30?
That's fine, Judge.
The matters that were appealed are still up in front of the 4th DCA.
So I'll bring up the appellate situation, appellate courts.
The last document in the case, or there may be one more that they need to file, one more reply brief. I would suspect that it's going to be set down for oral argument, and then I don't know when we will get a ruling. The problem is the stay that was issued by your previous judge. We cannot go into anything on any type of discovery as far as depositions, as far as motions, as far as anything dealing with the matters that are up on appeal. So when that all comes back, we will be rushed to get everything else done. Just want to let the court know, we're under the mercy of the 4th.
Is there anything pending at the 4th DCA regarding the tampering?
Yes, everything that was on the homicide is also on appeal for the tampering because it's the same evidence.
Yep.
And Judge Murphy entered an order.
Entered an order that says you can't do depositions?
We can do depositions on things that aren't on appeal. So we have been doing depositions on things that aren't on appeal.
For example, you did not read, unless I missed it, but there's a motion in which I'm asking the court to make the state tell us what of the 2 million or whatever amount of Instagram messages they intend to use at trial. That was filed a long time ago. We can't have that hearing because the Instagram messages, the whole thing is up on appeal.
Oh my god, the 2 million Instagram messages are part of the appeal, so they can't even fucking figure out which ones they're going to use or not.
Even go into that motion. Those are some of the things that await you.
Well, couldn't I give you rulings on all those, depending on what, if I rule some messages are in and some messages are out, your example, and the 4th DCA says they're all out, then they're all out.
Judge, I wanted to move this case. I'm just...
Do you have any objection to doing that?
We're not the ones that filed this day.
Do you all have an objection to doing that?
Well, I think I'm confused on the motion that you're bringing up because all of the Instagram, if I remember correctly, I have to look, is up on appeal.
Right.
So, I mean, it would kind of be a waste of time to do the motion.
Oh, no, a waste of time is reserving 2 entire court days and doing nothing. That's a waste of time. So do you have any objection to going forward and hearing and ruling on any and everything that's pending?
I think that we should start with the things that don't affect the appeal, and then, because there's plenty of those to be heard, and then we can go forward.
You can just tell by her tone, she's using the appeal as a way to delay the trial. And I've said this like 9 months ago when they first did the appeal. Because they appealed something that they know is pointless. It wasn't even something worth appealing. It was an evidence decision. I don't remember even what it was because it was a fucking year ago or something.
And I'll be candid, I did not think we were hearing the Instagram matter whatsoever. So I have not looked at that motion.
Okay, so why don't we do it this way, all right? He's going to remain on the docket tomorrow. I have a few other matters on both FX and FT, so let's call it 9:30 tomorrow. And defense, you can come in and tell me if you had a chance to talk to your client. Because waive any potential conflict, I guess it doesn't matter.
Yes, it does, Your Honor, because he'd be waiving a conflict without knowing what's in the search warrant affidavit.
Correct.
So therefore it would be an invalid waiver because he's not totally informed of the facts.
Okay, you're going to tell me what you want to do, state. Maybe you can identify the motions that you think we can go forward. I mean,
We sort of addressed it in the motion to strike the notice because we've been asking since our hearing in October to know what motions are going forward the next 2 days. Couldn't get an answer. We've asked in depositions from Ms. Liberty, couldn't get an answer. We emailed, we couldn't get an answer. And then just a few days ago, we got a notice of hearing. Half those motions aren't even filed within the court file in Odyssey. So we identified, I think, 4 that we are ready to go on, that we filed responses on. There's no motion.
Look at this judge's face. He's already just realizing this is a shit show. This is an absolute disaster dumpster fire.
Filed for some of these.
you're going to go to trial in September. I'm not prejudging things.
I hope so, Judge.
No, I can absolutely guarantee you, he's going to go to trial in September. So I'm going to do everything that I can. If I have to rule on things during trial, which is an awful way to do things, because I know you both know, but if that's what it comes to, then that's what we're going to do.
Judge is saying they ain't delaying shit. He absolutely guaranteed Melly's going to trial in September in 9 fucking months. What a shit show.
Okay, I'll see you at 9:30 tomorrow.
And there was the first hearing for Melly in months, and it ended like that. Basically, the defense begging on what his defense lawyer is being investigated for and the details to see if Melly needs to get rid of his lawyer or all of his fucking lawyers and then delay this trial even more. Can't believe this is real. Hit subscribe, join channel membership. Love you guys. Peace out.